ಅಲ್ಲ, ಅದರಲ್ಲೂ ಪ್ರಾಬ್ಲಮ್ ಸೇಮ್ ಅಂತಂದ್ರೆ ರಿಮಾಂಡ್ ಆಗ್ಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ. ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ MP MLA ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ.
I concede. Lordship, right away.
It should go before the.
But I concede only to that extent. I concede only to that extent that it has to be remanded to the
court.
But without the issues raised by them needs to be answered.
No, if the court has no jurisdiction, how will I answer those issues and send it back? I will send it back to the appropriate court. Magistrate cannot, regular magistrate cannot.
But there's a very serious issue that I've raised in that, Your Lordship.
Let the court consider, let the appropriate court consider and take cognizance.
I'm reminding this court with absolute humility the judgments that I had quoted about 12, which says any court can take cognizance of the crime committed within the court.
See, any court, as long as there is no designated special court.
No. Not that issue. A fraud committed on the court.
Fraud committed on the
orders court, obtained by fraud.
If you are saying fraud committed on the court, it should be a document of custodia legis. Then that court only will have to complain. Now this, whatever cognizance now it is taken by the normal court, the regular magistrate would not apply to a designated court. It has to go back to that court. Same procedure will follow.
That I agree.
There are so many orders on that ground, sending it back to MP MLA court.
That I'm not at all saying no, Your Lordship. Even otherwise, if it is the March 3rd, I would have gone and made an application before the court and said there is an issue raised, there is a lapse.
That will 67 will close that then on that ground. We'll see. Al Barli 67 Barli.
Basically, I'm too important and serious legal issues. If that appeals to Your Lordship, probably I need
then
not
we'll go to the legal issues.
Go to the facts of the case and all that. Now, I for myself feel, my Lord, in the fitness of things and in fairness to the complainant, that the matter warrants an order of remand at Your Lordship's hands in the event of my Lord agreeing with my legal submissions. That's all. Well, this is a private complaint. Complaining of an offense of forgery and user of a forged document, knowing or having reason to believe that the document is forged. That is made penal under section 465, 468 and 471. That the court would take cognizance and would issue process against the accused. The accused would enter into his appearance in the case. But in view of the fact that the complaint is a private complaint, my Lord, the procedure that is mandated under Chapter 15B has got to be followed. May I just request Your Lordship to kindly turn to Chapter 19B.
19 CRPC.
CRPC, old.
Sorry, Your Honor. Which petition is being?
Which petition? 11172.
11172.
Yes.
The case 19B. Cases instituted otherwise than on police report. So kindly pause for a minute. For my understanding, my Lord, I am making this submission. Well, if it is a police report filed under 173, for the purpose of framing of charges or for the purpose of passing an order of discharge, the court will have the advantage of the report as filed under section 173(2) of the CRPC. It leaves no doubt. The report that is filed under 173(2), my Lord, contains the statements of witnesses, the documents, if any, the investigator collected during the course of the investigation of the crime and whatnot. After a perusal of the record of the case, my Lord, be it under 227 or be it under 239, that is the statement of witnesses and the records, the court would make up its mind whether charges have got to be framed or the accused is entitled for an order of discharge. But in a private complaint, there is a case which is instituted otherwise than an appropriate.
Yes.
May I just invite my Lord's kind attention to section 244 first. When in any warrant case instituted otherwise than a police report, but this is a case that is instituted a warrant procedure otherwise than in a police report, it leaves no doubt. The accused appears and is brought before the magistrate. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Kindly pause for a minute. Well, the law enjoins a duty, be it upon the court or be it upon the complainant, my lord, to produce all such evidence. I'm sure your lordship would certainly agree with me. The trial judge says it is only the examination chief is evidence and cross-examination and re-examination is not evidence. I'm sure your lordship would certainly agree with me. Evidence that is found under section 244 is not confined only to examination in chief. It certainly includes cross-examination and re-examination. Let me repeat it. The risk of repetition requires that accused appears or is brought before them. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Here the prosecution is the private party, a complainant has got a lead evidence. The magistrate may, on the application of the prosecution, issue summons. But here even summons could also be issued to the witnesses, to any of the witnesses, directing him to attend or to produce any document or other thing. If upon taking all the evidence referred to in section 244, well, even under section 244, your lordship would get or take all such evidence. Now under 245 also, if upon taking all such evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. But the evidence that is led under section 244, there is only examination in chief or cross-examination and the re-examination. If it were to remain intact on record in the case without being subjected to the test of cross-examination, the magistrate should be in a position to give a finding. Well, that is sufficient to hold the accused guilty.
Now, what has the court done?
I'm sorry, my lord.
What has the court done now?
Court says it is only examination in chief alone that could be looked into.
So you filed an application for compliance with 244?
No, my lord, I have cross-examined the witnesses.
Oh, you already cross-examined?
Yes. But next, only one sentence, then I shall take your lordship to the finding that is given, and then the law laid down by the Supreme Court. Well, now kindly go to 245, my lord.
Yes.
Leave the evidence led by the complainant in the absence of a touchstone method of that evidence being subjected to the test of cross-examination.
Yes.
If that were to be left alone, unrebutted, without being tested, subjected to the test of cross-examination, that should infuse a confidence in the judicial mind of the court that is sufficient to hold the accused guilty. Otherwise, no, my lord, he can't do it. Under section 245, my lord, then, my lord, comes 246. If when such evidence has been taken, here also your lordship would get evidence, 245 evidence, 246 evidence, 244 also evidence has been taken, or at any previous stage of the case, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offense tribal under this chapter, which such magistrate is competent to try and which in his opinion could adequately be, he shall frame the charges in writing. So the basic essential requirement for the court
is that it is at the stage of framing of charge. No, it is crossed that.
No, my lord, I would make an application requesting the learned judge to exercise his jurisdiction under section 245, no sooner the evidence is recorded, to pass an order of discharge in my favor. May I invite your lordship's kind attention to the order, my lord, without going into the evidence. I don't want to take your lordship to the evidence at this point of time. If it becomes necessary, certainly I shall do it. May I invite your lordship's kind attention to the order at page 100, commencing from page 178. Kindly go to page 178.
Yes, sir.
I think it would be useful for me to invite my lord's kind attention straight away to the finding which my lord gets at page 186 first, then I will go back. My lord, with all humbleness, let me submit to your lordship. This judge thinks that he knows better law than his predecessor in office. He writes it. He writes it. But may I request your lordship to kindly go to page 186, para 22. As already discussed here in above, after the evidence of prosecution under section 244 of CRPC, the stage is for charge or discharge of the accused under section 245(1) of CRPC. It is thereafter, Lord may kindly note this, it is thereafter the accused gets the choice of cross-examination of complainant and the prosecution and its witnesses. However, maybe due to inadvertence, in this case, my predecessor in office had allowed the accused to cross-examine PW1 prematurely before the charge, before the stage of under section 245(1) of CRPC. As such, that portion of premature cross-examination of PW1 by the accused cannot be considered at this stage of section 245(1) of CRPC. Because if such cross-examination of PW1 is also considered at this stage, it would amount to final appreciation of evidence for arriving at a final conclusion, and that would lead to the judgment of conviction or acquittal. But this is certainly unacceptable. It is an assault on the provision of...
Yes, what are the judgments?
I'm sorry, man.
Judgments.
Any number of judgments I shall. Still, if my lord feels...
Yeah.
ಅಲ್ಲಲ್ಲ ಇವ್ರು ಬರೆದಿರೋದೆಲ್ಲ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಎಲ್ಲ ತಪ್ಪ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಬರ್ದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is number one. Well, kindly go to the second issue, legal issue that is involved in the case is this. Well, probably to buttress his claim, the complainant would send certain documents to the private forensic science laboratory. That is
private laboratory?
Truth
labs.
Truth labs. ಅದರಲ್ಲೂ ಏನಿತ್ತು ಹೇಳ್ಬಿಡ್ತೀನಿ, ಒಂದೇ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಜಾಸ್ತಿ ತಗೊಳ್ಳಲ್ಲ. ಆಮೇಲೆ the truth lab would give a report. May be or may not be in favor of the complainant. Let us not go to that report now. But what came to be sent to the laboratory for the purpose of comparison, but it is crystal clear that in the science of handwriting, my lord, what is needed to be sent to the expert for comparison and his opinion are threefolded. Number one, question document or a disputed document. In common parlance, we call it as disputed document. Well, scientifically, they call it as question document. Number two, standard writings or standard signatures. Writing or a signature which has come into existence at an undisputed point of time. Number three, a specimen writing or a specimen signature. These are the basic documents that are needed for the purpose of comparison of a writing or a signature by an expert. It is only thereafter, my lord, by using some technical devices and all that, he has got to compare the writings and signatures vis-a-vis the question document and then give his opinion. But what came to be sent to the truth lab are all Xerox copies of the documents. That is impermissible.
Where do you get that?
Yes, I shall take your lordship now to that. And what the learned judge says is, does not matter whether it is a original or a Xerox, he has given opinion. And he is not even examined. And under 244, all such evidence, marking of a report through the complainant who has nothing to do with that document, cannot be read in evidence. May I now invite your lordship's kind attention to kindly go to page 176 at paragraph 13. 13.
170?
176, 176 at paragraph 13. But I'm only on two important legal issues. It is only for that limited purpose I'm drawing my lord's kind attention. Para 13. That apart, the complainant has also got compared and examined the signature of the accused number one. Exhibit P6 through an expert of the Truth Labs, Bengaluru, and obtained the report as per Exhibit P22. On considering all the above documents with the testimony of PW1, prima facie it appears that there is such a difference in signature of accused number 1 in Exhibit P6 and other documents which could be noticed with naked eyes by any prudent man. Similarly, there appears to be some similarities in the nature of signature of accused number 1 in Exhibit P6 and the signature of accused number 2 in Exhibit P9. Therefore, the documentary evidence produced by the complainant in his examination in chief prima facie corroborate the allegations of complainant as to the forgery of signature of accused number 1 in Exhibit P6, though the said documents are subject to test and proof by way of cross-examination by the defense counsel. Now, my lord, kindly go to page, because your lordship asked me a question about the Xerox copies having been sent. Where do we get it? Kindly go to paragraph 180, paragraph 17, page 180, paragraph 17. Further, as rightly argued by the learned senior counsel for submission, well, finding is in my favor, but the result is against me, unfortunately. Further, as rightly argued by the learned senior counsel for submission of the said form number 6, the personal presence of the accused number 1 was not mandatory. No doubt, such a form of a person could be submitted by any of the agents or workers, but such form should prepare and signed by the accused number 1 himself, but not anybody else. As such, in the present case also, there was no bar for the accused number 2 to submit the said form number 6 of the accused number 1 to the electoral registration officer. Said form number 6 should have been duly signed by the accused number 1 himself. It is the allegation of the complainant that the same was signed by the accused number 2, as if it was signed by accused number 1, who was not at all in India at that particular point of time. Therefore, the issue as to the forgery of signature of accused number 1 by accused number 2 is for trial in this case, but not the issue as to the filing of submitting the form number 6, etc. Then, my lord, he also admitted, down below, etc. Probably we can skip all those things and then kindly go to straight away.
But this line of argument cannot be considered at this stage.
He can't consider it. He said, well, I shall just show to your lordship. Kindly go to page 189, paragraph 25. This here your lordship would get it. Because this would clear your lordship's question to me. Paragraph 25. No doubt on perusal of the records, it appears true that the complainant for getting the said expert opinion in Exhibit P6 had not supplied the originals of the said form number 6 and also not supplied specimen signatures of accused number 1. But he has supplied Xerox copies of the said Exhibit P6 to the said Truth Labs along with the documents containing standard/admitted signatures of accused number 1. On the basis of the same, the expert of the said lab has given his opinion as per Exhibit P22. Whether the said opinion could be accepted or not could be considered only upon his examination, which he has not done. He places reliance on that, says it is a case of forgery. Opinion on the basis of the said Xerox copy of Exhibit P6. Moreover, any such expert opinion or scientific report may not be a sole and substantive evidence to decide the issue in this case. It may be one of the corroborative piece of evidence. Well, what was sent to the expert, that is the Truth Lab, for opinion, examination and opinion, are 3 Xerox copies of the documents, and on the strength of those 3 Xerox copies of documents, not even the specimen signature, well, the opinion came to be given. And even otherwise, well, the expert having not been examined under section 245, the learned magistrate ought not to have placed reliance on the opinion that is marked through the complainant, who has nothing to do with this. Now, straight away, let me invite my lords. I have many more points, but this is sufficient for me at this point of time, would be my respectful submission.
Yes, Abraham. Only these legal submissions.
One more minute.
Oh, no, yeah.
One more. In fact, the Supreme Court has come upon this Truth Lab heavily.
Truth Labs.
ಅದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. untrustworthy, dishonest. Let me invite my Lord's kind attention to first judgment of the Supreme Court, my Lord, on the point. Lord, even in law college also we are taught, my Lord, evidence means examination in chief, cross-examination and re-examination. And I invited my Lord's kind attention to the finding given by the learned magistrate. Only examination in chief. No, I can't look into it. My predecessor in office has committed a serious...
The basic thing is, if something has to be considered for the purpose of discharge, it cannot be only on one side's evidence.
Well, that is what the Supreme Court has said.
That is what I know.
Straight away, let me invite your Lordship's attention to the judgment of the Supreme Court, 2013.
In fact, in this criminal petition 11172, Your Lordship.
No, it's senior counsel is only on legal submissions.
I was just making a submission.
Let him finish.
They have not given me an incomplete.
Let him finish.
Incomplete petition.
All right, we'll see.
That's okay.
Have
not been given.
Incomplete petition. This incomplete petition.
Petition legal issue. Order and judgment.
Order.
What I had to do was look at the list of documents, and I had to prepare the
You want time, sir?
No, sir.
You request the court, and then why is that issue?
Senior finish, wait.
If he wants time, let him take time. It is up to your Lordship to grant him time or not to grant him time.
No.
I will not come in the way. If the papers which I have given to him are incomplete.
These are the two legal issues.
Papers.
These are the two legal issues to be answered.
Legal issues, papers.
You want time?
Legal issues.
No, to answer these legal issues.
Anything.
Not on the merit of the matter.
No.
Not on the merit.
I will.
Yes.
Well,
it's already answered, Your Lordship.
No, that is what is wrong is said.
No, I'm saying this court has already answered.
Then we'll see. Yes.
Why would I answer it again?
But this is in 2013. Volume 9, Supreme Court Cases 209.
Paragraph.
May I request your Lordship to kindly turn to paragraph 18 first and then go to 19. This was also a case of private complaint. Evidence recorded under section 244. As in this case, the trial court would also say it was only the examination in chief that would be looked into. Paragraph 18, internal page 218 of the judgment. My Lord gets it?
Yes.
Secondly, because the evidence under chapter 19b has to be recorded in the presence of the accused, and if a right of cross-examination was not available to him, he would be no more than an ideal spectator in the entire process. The whole object underlying recording of evidence under section 244 after the accused has appeared is to ensure that not only does the accused have the opportunity to hear the evidence adduced against him, but also to defend himself by cross-examining the witnesses with a view to showing that the witnesses is either unreliable or that a statement made by him does not have an evidentiary value or that it does not incriminate him. Section 245 of the code, as noticed earlier, empowers the magistrate to discharge the accused if upon taking all the evidence referred to in section 244, he considers that no case against the accused has been made out, which may warrant his conviction. Whether or not a case is made out against him can be decided only when the accused is allowed to cross-examine the witnesses, but otherwise he may not be in a position to demonstrate that no case is made out against him and thereby claim a discharge under section 245 of the code. It is elementary that ultimate question in any judicial determination is to arrive at the truth, which is not possible unless the deposition of witnesses goes through the fire of cross-examination. In a criminal case, using a statement of a witness of the trial without affording to the accused an opportunity to cross-examine tantamounts to condemning him unheard. life and liberty of an individual recognized as the most valuable right cannot be jeopardized, leave alone taken away, without conceding to the accused the right to question those deposing against me from the witness box. Thirdly, because the right of cross-examination granted to an accused under section 244 to 246, even before framing of the charges, does not in the least cause any prejudice to the complainant or result in any failure of justice, while denial of such right is likely and indeed bound to prejudice the accused in his defense. The fact that after the court has found a case justifying framing of charges against the accused has a right to cross-examine the prosecution witnesses under section 246(4) does not necessarily mean that such a right cannot be conceded to the accused before the charges are framed, or that Parliament intended to take away any such right at the pre-charge stage. But under section 246, the accused is again given a right. Already those witnesses who are examined under section 244, do you wish to recall them for the purpose of further cross-examination? The learned judge thinks under section 246, you get an opportunity of cross-examining the witness. Therefore, the cross-examination cannot be looked into. That is an assault on the statute, would be my respectful submission. But the second judgment, I think, I don't know whether I should be your lordship in any number of judgments are there of this court.
No, but page 183, annexure R11.
180?
183, annexure R11 of his objection. Same ground taken in criminal petition 5014 of 2022.
No, my lord.
Huh?
He was not even cross-examined.
No, come R11.
No. That was, an opportunity was not given to cross-examine me was the criminal petition. That is Honorable Justice Sunil Dutt Yadav's order, my lord.
Discharge
Yes.
or on discharge.
He was not even cross-examined.
Not
Cross-examined. Then, my lord, the Honorable Court would remit the matter. And then after remittal, an application came to be filed seeking recall of PW1 for the purpose of cross-examination. That was granted. Then, my lord,
yes.
this finding comes into play.
Yes.
My lord, may I request you? 183, my lord?
Ah.
Yes, have a look at this, my lord.
Yes.
This was again a legal issue without even cross-examination of PW1. What the learned judge for the purpose of proceeding to frame charge did was she would refer to the law laid down by the Supreme Court under section 227 and 239. 227 is a police report. 239 is also a police report. There, my lord, the cross-examination of witnesses will not be there. Here under chapter 19B, my lord, because it is a private complaint, the cross-examination will be there. That was a question which came to be raised. In fact, his lordship would write that. May I request your lordship find it, go to paragraph 5, my lord. There's only one page.
That one short judgment I've seen.
Yes. Therefore, his lordship would say, no, 227 judgments, you can't apply to this. It is a private complaint. It is only after that order of directing framing of charges came to be set at naught by the High Court, by this court, in this criminal petition 5014, we would make an application because it was not cross-examined on that day, at that time. Then, my lord, the court would allow that application. I was permitted to cross-examine the witness. That is PW1, the only witness is the complainant. Complainant was, his say was subject to the test of cross-examination. Thereafter, my lord, he was required to examine the purpose. Then, my lord, ಬೇಕಾದಷ್ಟು
ಜಡ್ಮೆಂಟ್ಸ್ ಇದೆ
ಅಲ್ಲ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇದೆ
ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಗೊತ್ತಿಲ್ಲ
ಅಲ್ಲ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಅಲ್ಲ ದಟ್ ಇಸ್ ಬೇರೆ ಅವರ್ ಹೈಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಮೇಲೆ therefore it is invalid, you can't look into it at all, is the law laid down by our high court. But that is it, otherwise it defies elementary logic and common sense. But Xerox copies, keep it, print it and take it and send it in the absence of original and all that can't be done. Even in another judgment, my lord, in what the Supreme Court has said, same thing. Well, we saw this section 244, 245, and 246. In only one paragraph, my lord, I shall just read it and be done with it. This is in 2009, volume 14, Supreme Court cases 115. Only one paragraph. Kindly go to paragraph 51 at internal page 131 of the judgment.
This is followed.
That is followed in that judgment. But here, my lord, it is more elaborately is written. The right of cross-examination is a very salutary right, and the accused would have to be given an opportunity to cross-examine the witnesses who have been offered at this stage of section 244(1) of the CRPC. The accused can show by way of cross-examination that there is no justifiable ground against him for facing the trial, and for that purpose, the prosecution would have to offer some evidence. While interpreting this section, the prejudice likely to be caused to the accused in his losing an opportunity to show to the court that he is not liable to face the trial on account of there being no evidence against him cannot be ignored. Well, the Lawrence judge does not even refer to it, and he says, no, I am not going to look into it at all. And he did not. He did not look into it. But as far as expert evidence is concerned, can't be looked into.
Yes, sir.
Well, these are the two important serious legal issues. If my lord is persuaded to accept my submissions,
Then
my lord,
I will go into the merits.
then if my
I'm
lord
not-
does not accept my submissions, my lord, then your lordship may permit me to take your lordship to the merits of the matter. Because the learned trial judge does not even refer to one sentence in cross-examination. Not even one sentence.
No, according to him, it is wrong.
No, according to me, it is not necessary.
Not
His
necessary.
predecessor committed a sin. His predecessor committed a wrong. He ought not to have permitted me to cross-examine the witness.
Yes, sir. Only on those 2 points.
Your Lordship,
244,
primarily,
245.
the issue that was raised in 5015, I had submitted a chart the other day, a comparison chart
Yes, it's here.
between 11172 and the previous criminal petition 5014.
Yes.
The grounds, the facts, cut and paste. Now,
Same thing.
the
501.
only now to cut short the my submission, I would straightaway take this court to what is the order of this court in
501.
5014.
Yes.
The learned senior counsel would surely convince his court, if it is otherwise, that he had not put forth all these contentions before this court in 5014.
They were pleaded.
Yes. And it was addressed. It has been addressed by the court also.
Yes. I am
Now-
at page 185.
It's not in the compilation of
Not
their
in compilation.
compilation. I have it. I have it with me.
Allah, R11 is that order.
R11 ಇಲ್ಲ ಇರೋ ನನ್ನ ಹತ್ರ
ಇಲ್ಲಿ ಏನ್ R11 ಮತ್ತೆ ಇದು order?
ಇವ್ರು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ unfortunately this happens.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಬ್ರಾಮ್ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ R11 ಅಲ್ಲಿ ಇದೆ.
Yes, Your Honor.
ಅದನ್ನೇ ಹೇಳಿದ್ವಿ.
5014.
Page 183.
I would like this court to glance through page 160, Your Honor.
Okay.
It is their petition 5014. What is their prayer, Your Lordship? Can they point out to this court where it was different from this petition, Your Lordship? What is the difference between this petition and the other petition? That was dealt by this court. A reasonable order has been passed. The only problem was in criminal petition, the other day when I made my submission, I did make a submission that as far as the discharge application was being heard, it was Mr. Suman who was the senior counsel who represented the. I brought that to the notice of this court. At the conclusion of that submission, I offered to the court, if it is required, I don't mind giving citations because it is similar. I gave the court a chart, write-up, which was very convincing, which is not necessary for you to. Mr. Suman agreed that it is on the same principles, more or less. It doesn't matter. But unfortunately, he's not here, and senior came and he exercised his right to question it. He has questioned it, and it has been answered by this court. What does this court say? What is the final order of this court? Let me lead this court to the finding. At page 189, Your Lordship, the trial court in paragraph 10 has proceeded on the premise of the test and standard under section 227, which is qualitatively different as regards to the test to be answered under section 245. It would not be appropriate to enter into the merits of the case, because the merits of the case was presented in that case also, Your Honor. As the matter is being remanded for fresh consideration, it would also be necessary to observe that after disposal of the application under 245, the court, while proceeding to frame charges, must also apply its mind to the stage of 246, and an order in that regard be passed. Accordingly, the impugned order is sent. Have they pointed out in the impugned order one thing that the trial court judge has not done, other than making an allegation that the trial court judge has not applied his mind? He has several times non-application of mind, non-application of mind, non-application of mind. I don't understand what they're trying to tell this court. What are they trying to impress this court about the trial court judge? I have a feeling the petitioner wants to tell this court the trial court judge does not deserve to continue.
You make your submission.
Now, on this,
don't worry about what they're...
Yes, Your Lordship. On this, not a single word. What did this court ask? Go back. It is sent back, and it is directed the trial court, to pass an order accordingly. Accordingly, an order is passed. Prima facie is established. This truth lab has been discussed. Everything has been covered. And now they do not, I don't know on what ground they will continue to say this. With this chart is very demonstrative that the entire thing is a repetition of the previous case. Entire thing.
So according to you, the pleadings are in repetition. The court has already considered it. And passed an order. There is no warrant of interference
Nothing.
Entertainment of repetitive submissions. That's all.
If the court permits me.
No, on the merit will not go.
I would.
If I don't agree with the senior counsel now.
Okay.
Then we will pass orders on that and hear both of you on its merit.
Fine.
All right. Then
if I'm given a little time on the merits, briefly, when senior counsel is there. No, Your Lordship.
Since these are legal
document-wise, I will lead this court.
Definitely, I will hear that. In the event I don't accept this 245, 246 submission.
Obliged.
Heard the learned senior counsel.